All right, I'm going to go ahead and get started. Good morning. My name is Amanda Jarvis, and I'm with the Virginia SBDC Network. For those of you that are not familiar with our organization, the Virginia Small Business Development Center is a partnership program between the U.S. Small Business Administration, George Mason University, and local host institutions throughout Virginia. With 27 locations across the Commonwealth, we provide training and technical assistance to small businesses in their local communities. Our one-on-one consulting services are available at no charge. Today's webinar, Copyright Basics and Considerations for Entrepreneurs, is presented by the Virginia SBDC Network in collaboration with the U.S. Patent and Trademark Office. We are recording today's presentation and it will be posted on our website, virginiasbdc.org. Due to the large number of participants, everyone's microphone is muted, but if you have questions during the presentation, you can type those into the Q&A box. We have also enabled the live transcript function, which you can show or hide via your meeting controls. And now it is my pleasure to introduce our presenter for today's session. Marina Gipsov is an intellectual property attorney by occupation, artist at heart, and children's book author by dream come true. Marina has been working as a trademark examining attorney at the United States Patent and Trademark Office for over 3.5 years. She is currently on detail at the Office of Policy and International Affairs, working on various copyright policy issues, both domestically and internationally. Please join me in welcoming our presenter for today, Marina Gipsov.
Thank you, Amanda. Thank you for the introduction. It's great to be here. Today, I will talk about one of my favorite topics, copyrights. Specifically, I will go over copyright basics as well as certain considerations that may be helpful to entrepreneurs and small businesses. So let's begin. For centuries, copyright has been an engine for creativity. I think the slide 2, if you could do, Amanda. Yeah. Yes. So as I mentioned, for centuries, copyright has been an engine for creativity. In today's global digital environment, authors, entrepreneurs, and businesses have unprecedented opportunities to disseminate their copyrighted works, their creative works, to a worldwide audience. In pursuing these opportunities, creative industries depend more than ever on their ability to protect and enforce their copyrights. Let's first talk about the purpose of copyright. In the United States, the purpose of the copyright law is set forth in the Constitution, as you see on the slide. Article 1, Section 8, Clause 8 of the U.S. Constitution states, "The Congress shall have power to promote the progress of science and useful arts by securing for limited terms to authors and inventors the exclusive right to their respective writings and discoveries." So what does this clause mean? It means that copyright's ultimate purpose is to protect authors and to encourage creativity and innovation. So the next question of importance is, what is a copyright? Copyright is a form of legal protection provided by U.S. law to the authors of original works of authorship that are fixed in any tangible medium of expression. I will talk about the originality and fixation in a bit. In the meantime, let's see what types of works are protected by copyright. Next slide, please. Next slide. Section 102 of the Copyright Act establishes 8 broad categories of the protectable subject matter of copyright. On this slide, you can see some examples of the copyrightable works, which include musical works, including accompanying words, lyrics, literary works such as books, audiovisual works such as movies and TV shows, pictorial, graphic, and sculptural works such as artworks, photographs, and sculptures. The list also includes many other forms of creative works, such as sound recordings, plays, choreography, architecture, software, maps, and compilations. This brings me to the next question. Why is copyright important? Next slide, please. The answer is simple. Some business assets may be protectable by copyright, and as such can be a valuable intellectual property asset. This may include the following: advertising and promotional materials, instructional manuals and educational materials, software, website, including artwork, text, photographs, and other forms of authorship protected by copyright that are featured on website, artistic elements of logos, like product logo artwork, and product design and packaging. While the last category is rarely protected by copyright, it is still worth keeping in mind. Next slide, please. And now let's go over requirements for copyright protection that are set forth in Section 102A of the Copyright Act. The first requirement is originality. To be protectable by copyright, a work of authorship must be original. That meaning that it must be independently created by a human author and exhibit at least some minimum degree of creativity. This was also featured in the case FICE publication that you can see on the slide. The second requirement for copyright protection is fixation. To be protectable by copyright, a work must be fixed in any tangible medium of expression, now known or later developed, from which they can be perceived, reproduced, or otherwise communicated, either directly or with the aid of a machine or device. In this sense, the manner and medium of a fixation are virtually unlimited. Next slide, please. I mentioned the protectable subject matter of copyright earlier, and now let's take a look at the subject matter that is not protected by copyright. Under US law, the following subject matter is not protected: works that are not fixed in a tangible form of expression. For example, a choreographic work that has not been notated or recorded, or an improvisational speech that has not been written down or recorded. The next category is titles and names, familiar symbols or designs, mere variations of lettering of typographic ornamentation, lettering or coloring, and mere listing of ingredients or contents. The next category is individual words and short phrases. Also, ideas, procedures, methods, systems, processes, concepts, principles, or discoveries are not protected by copyright. And finally, works of the US government are not protected by copyright either. Next slide, please. As I just mentioned, ideas, procedures, methods, systems, processes, concepts, principles, or discoveries does not constitute copyrightable subject matter. This is called an idea expression dichotomy. It ensures that copyright protection extends only to the specific expression of an idea rather than the idea itself. This means that copyright owners do not have the right to prevent others from using the ideas, concepts, principles, or discoveries, or from implementing the procedures, processes, systems, or methods of operation described in such works. Examples of such unprotectable elements include the idea for a character of the book, ideas, procedures, processes, of methods for doing, making, or building things, scientific or technical methods or discoveries, business operations or procedures, mathematical principles, formulas, algorithms, or equations. Next slide, please. And now I will talk about the bundle of exclusive rights of authors. Under US copyright law, creators are granted a number of exclusive rights that together comprise the bundle of rights, exclusive rights of an author. Section 106 of the Copyright Act provides the copyright owner has exclusive rights to do or to authorize any of the following: make copies of the work, prepare derivative works such as adaptations or translations, distribute copies of the work, publicly display the work, publicly perform literally musical, dramatic, choreographic works, pantomimes, or audiovisual works, publicly perform a sound recording via a digital audio transmission. Next slide, please. And now I'd like to talk briefly about copyright in the international context. The important point here is there is no such thing as an international copyright that automatically protects a creative work throughout the world. Protection against unauthorized use of copyrighted works within every country depends on the national laws of that country. The US Copyright Act, like the copyright laws of other countries, is effective within the territory of the United States. However, it does not operate in vacuum. In fact, several elements of the US copyright law owe their existence to international copyright treaties and conventions that the United States has joined over the years. This slide lists the 4 treaties that establish minimum standards for protecting works under national laws and for extending protection to the work of other treaty members under the principle of national treatment. The principle of national treatment requires each member state to accord to nationals of other member countries the same level of copyright protection provided to its own nationals. There are other treaties on copyrights and related rights, but these are the major ones. Berne Convention for the Protection of Literary and Artistic Works of 1886, WTO Agreement on Trade-Related Aspects of Intellectual Property Right, or TRIPS, of 1994, WIPO Copyright Treaties, and WIPO Performances and Phonogram Treaty of 1996. Next slide, please. Let's move on to the next point of discussion, copyright registration. Next slide, please. But before I talk about copyright registration, I'd like to take a moment to explain how copyright protection is secured in the first place. Copyright protection is secured automatically upon creation. A work is created when it is fixed in a copy of phonorecord for the first time. Accordingly, no publication or registration is required for copyright protection to attach to work. There are, however, certain advantages to registration. Next slide, please. I will now explain the benefits of copyright registration in more detail. First, it establishes a public record by putting others on notice of copyright claim. This helps people who wish to license your work to ascertain its status and locate copyright owners. Second, registration is a required prerequisite for US copyright owners for bringing a copyright infringement suit in federal court, but this is required for works of US origin only. Copyright owners of non-US copyright works need not register their US copyrights before filing suit. In addition, registration provides prima facie evidence of validity of the copyright and facts stated in the registration certificate if made within 5 years of publication. This could be important should the copyright infringement action be brought to the court. Further, registration may be recorded with the US Customs and Border Protection to help prevent importation of pirated products like pirated CDs and DVDs with music or movies or books. Registration is also important because it entitles a copyright holder to certain remedies for infringement, such as statutory damages and attorney's fees, which I will talk about in more detail a bit later. Note that under US law, no statutory damages can be awarded unless a registration is made within 3 months after the first publication of the work. This provision encourages copyright owners to register their works. Finally, registration makes it easier to license work, collect royalties, and enforce rights outside of court. Next slide, please. Registration is administered by the US Copyright Office, which is part of the Library of Congress. It may be made using paper forms or submitted online. For more detailed guidance, you may check out the Copyright Office's tutorials for single, standard, and supplementary applications. Next slide, please. The registration process involves the following steps. To register a claim to copyright with the Copyright Office, a copyright owner must file a properly completed application, pay a filing fee, and deposit copies of the work to be registered. This may be done electronically or by mail. When depositing by mail, a copyright owner must submit 2 complete copies of the best edition of the work. Note that not only does the electronic filing has a lower filing fee, but it also provides a faster processing time, as you will see in the moment on our next slide. It also provides an early effective day of registration and allows online status tracking of the application. So electronic filing has much more benefits than the regular mail filing. Copyright registration is effective on the date of receipt in the Copyright Office of all the 3 required elements: application, filing fee, and deposits. In addition, some of the registered works may be selected for the collections of the Library of Congress, which is another perk of registering a work with the Copyright Office. Next slide, please. Unlike patent or trademark registration, copyright registration does not involve a lengthy, complex examination of applications, and processing times average from 2 to 4 months for online claims and 11 to 12 months for mail claims. Current processing times can be checked on the Copyright Office's website, following the link that is shown on the slide. Once the application is filed and deposits are received, Copyright Office specialists conduct a simple examination of each work to determine copyrightability and compliance with legal requirements. Only a small percentage of applications for registrations are refused. Next slide, please. I'd like to make a note of a recent case that dealt with copyright registration. The U.S. Supreme Court recently held in Unicolors versus H&M that inadvertent legal mistakes during the application process cannot form the basis for invalidating the copyright registration. This decision is important because it should make it easier for individual creators and small businesses who choose to register their copyrights on their own to avoid invalidation of their registrations. Next slide, please. Let's turn to the topic of copyright notice. You might have seen various forms of such notice in connection with books, software, or movies. The slide shows some common examples like the C symbol, the word copyright, or the abbreviation COPR, and often includes the year of first publication of the work and the name of the copyright owner. Like I have the Jane Doe example on the slide. In 1989, to comply with the U.S. obligations under the Berne Convention, Congress eliminated the notice requirement as a condition for obtaining copyright protection. As a result, no notice is required for works published on or after March 1st, 1989. Since then, the use of notice has become optional. Next slide, please. If it's not required, why use a copyright notice then? Even though it is not required, it still serves a number of useful purposes. First, it informs the public that the work is protected by copyright. It also identifies the copyright owner and shows the year of first publication. Copyright notice may also benefit the copyright owner against an innocent infringement offense, which is not a defense against infringement, but may bear on the remedies, for example, reduced amount of statutory damages. Important practical tip: when using copyright notice, provide sufficient additional information so that a third party knows how to contact you to obtain permission to use the work. Next slide, please. Another important question is, how long does copyright last? The international minimum standard for the protection of copyright set forth in the Berne Convention is life of the author plus another 50 years after their death. Berne members, of course, are free to exceed this minimum standard. The United States, European Union, and some other countries have elected to do so. In the United States, for works created on or after January 1st, 1978 by individual authors, copyright protection begins from the moment of creation and lasts for the life of the author plus 70 years after the author's death. In general, protection lasts until the end of the calendar year after the author's death. For anonymous or pseudo-anonymous works, if the name of the author is not revealed, and for works made for hire, copyright lasts 95 years from the date of the first publication or 120 years from the date of creation, whichever expires first. The copyright in joint works lasts for the life of the last surviving author plus 70 years. Next slide, please. This brings me to another important topic, ownership of copyright. In broad outline, the U.S. Copyright Act recognizes three categories of copyright ownership: individual authors, joint authors, and works made for hire. The basic rule is that copyright initially vests in the individual author. The author is the person who conceived the work and fixes its expression in a tangible medium. A joint work is a work prepared by two or more authors with the intention that their contributions be merged into an inseparable or interdependent part of a unitary whole. Think of a book that was written by two authors. Joint authors are the co-owners of the copyright in their joint work, meaning they have an undivided share in such work. Either co-author is free to exercise any of the exclusive rights, even without consulting with the other. However, neither co-author may grant exclusive licenses without the consent of the other or do anything to destroy the value of their joint work. Under certain circumstances in U.S. law, the copyright in the work is not initially granted to the actual preparer of the work. In the case of works made for hire, the employer of the preparer of the work is considered the author. There are two types of works made for hire: those prepared by an employee within the scope of their employment, and those prepared by an independent contractor by special order or commission. The copyright in the work specially ordered or commissioned belongs to the person for whom the work was prepared, only if the work falls into one of the 9 categories listed in the Copyright Act, and the parties expressly agreed in writing that the work will be considered a work made for hire. A few examples of the 9 categories of these specially ordered or commissioned works are: a work created as a contribution to a collective work, as a part of a motion picture, as a translation, as a compilation. Next slide, please. Now let's talk about copyright infringement. Next slide, please. Under the U.S. Copyright Act, infringement is a violation of any of the exclusive rights of the copyright owner. The owner of a violated exclusive right has the right to bring an enforcement action. Next slide, please. In general, the elements of copyright infringement case include validity and ownership of a copyright in the work, violation by the alleged infringer of at least one of the copyright holder's exclusive rights. First element can be established by introducing a certificate of registration that constitutes prima facie evidence of the validity and ownership of copyright. Second element, the copyright owner must prove that the alleged infringer violated one of his or her exclusive rights. For example, that the alleged infringer copied original expression from the copyrighted work, which may be proved either by direct evidence like admission or by circumstantial evidence. Next slide, please. And now let's briefly discuss the issue of liability. First, under the U.S. Copyright Act, a person who does something without authorization that implicates one of the exclusive rights of the copyright owner could be held directly liable for the infringement. It's called direct liability. Under certain circumstances, however, a person may be indirectly liable for the infringing activities of others. This is called secondary liability, and there are 2 types of such liability: contributory and vicarious. Under the doctrine of contributory liability, a person may be liable for the infringing content conduct of another when he has knowledge of the infringing activity and induces, causes, or materially contributes to the infringing conduct. For example, the owner of a store could be held liable for the infringing activities of his customer if the owner sold them blank recording media while loaning them copies of copyrighted sound recordings. Under the doctrine of vicarious liability, a person may be found liable for the direct infringing conduct of others when the individual has the right or ability to control the conduct of the infringing party and financially benefits from the infringing conduct. For example, the operator of an outdoor flea market could be held vicariously liable for allowing vendors to sell infringing merchandise on the premises. Next slide, please. Let's turn to another important topic, exceptions and limitations to copyright. Our copyright law contains numerous exceptions and limitations to the exclusive rights of copyright owners. The first sale doctrine is an exception to a copyright holder's distribution and display rights. It provides that when somebody lawfully purchases a physical copy of a copyrighted work, like a book or a photograph, the purchaser may generally sell, lease, loan, gift, display, or otherwise dispose of his or her copy of this work. However, in the US, this exception does not apply to digital works, only to physical copies. Further, the Copyright Act establishes special exemptions for library, archives, and teaching, as well as certain statutory licensing for provisions for secondary transmissions of works by cable and satellite companies or digital transmissions of sound recordings. There are also certain television and radio exceptions, and those covering reproductions for blind or visually impaired people, and also making a single copy of a computer program for archival or maintenance purposes. The most important exception, however, is fair use. Next slide, please. Fair use allows the public to make reasonable use of copyrighted material under particular circumstances without copyright holders' consent or royalty payment. The Copyright Act provides a statutory framework for determining whether something is a fair use and identifies certain types of uses, such as criticism, comment, news reporting, teaching, scholarship, and research, as examples of activity that may qualify as fair use. Next slide, please. To determine whether the use made of a work in any particular case is fair, courts weigh the following statutory factors. The first factor is purpose and character of the use, including whether such use is of a commercial nature or is for non-profit educational purposes. The second factor is the nature of a copyrighted work. The third factor is the amount and substantiality of the portion used in relation to the copyrighted work as a whole. And finally, the fourth factor is the effect of the use upon the potential market for value of the copyrighted work. Courts evaluate fair use claims on a case-by-case basis, weighing all the four factors, and the outcome of any given case depends on a fact-specific inquiry. No single factor controls the analysis in isolation. All are weighed and balanced against each other, and the result will depend on the totality of the factors, not an arithmetic tally. Next slide, please. Generally, the fair use considerations are as follows. Is the use of the work commercial or for nonprofit purposes, such as criticism, commentary, education, or news reporting? Non-commercial uses are likely to favor fair use. Is the nature of the work factual, functional, or fictional creative? Courts are less likely to find fair use for creative or imaginative works. Is the use transformative? In that, is it altering the original with new expression, meaning, or message? Courts place great emphasis on whether the use is transformative. Such uses are more likely to be viewed as fair. How much of the copyrighted material is being used? Generally, the greater the amount taken, the less likely is that court will find fair use. And finally, does the use impact an existing market for the work or one that is likely to be exploited in the future? Courts evaluate the extent of the market harm that results from the particular action of an infringer. Next slide, please. And now let's briefly discuss the remedies available to copyright owners. The Copyright Act provides a broad range of civil remedies, including monetary awards, injunctive relief, attorney's fees, and costs. The prevailing party in a copyright claim has the right to recover actual damages, which include damages suffered as a result of the infringement and any profits that are attributable to the infringement. As an alternative to proving actual damages or profits, which sometimes may be difficult to prove, the Copyright Act permits the copyright owner to elect to recover statutory damages any time before the final judgment is rendered. The reason they are called statutory damages is because they are explicitly established by statute, ranging from $750 to $30,000 for each work infringed when infringement is not willful, and may go as high as $150,000 for each work infringed if the infringement is willful. The Copyright Act also provides for two kinds of injunctive relief: preliminary and permanent injunctions. To prevent or restrain ongoing copyright infringements, courts may grant a preliminary injunction. To prevent future infringing conduct, a court may grant the prevailing party a permanent injunction. In addition, a court may order the impounding of infringing copies on terms it deems reasonable, as well as materials used in the making of the unauthorized copies. A court may also order the destruction or other reasonable disposition of infringing copies, as well as the destruction of the machinery and equipment used primarily to produce them. Finally, a court may award attorney's fees and costs to the prevailing party in a reasonable amount. Next slide, please. The last topic that I'd like to cover involves an important recent development in the copyright law. In December 2020, Congress passed the Copyright Alternative in Small Claims Enforcement Act of 2020, or generally known now CASE Act, which directed the Copyright Office to establish the Copyright Claims Board, or CCB. The Copyright Claims Board is a three-member tribunal within the office that will provide an efficient and user-friendly option to resolve certain copyright disputes that involve up to $30,000, called small claims. The CCB can also hear claims for a declaration of non-infringement. Next slide, please. The Copyright Office is currently setting up the Copyright Claims Board that should be ready to hear claims by no later than June 25 this year. The advantages of the Copyright Claims Board proceeding include: it is a streamlined procedure with limited discovery. Most proceedings will be handled completely electronically, so no need to travel to DC. It is less expensive than federal court lawsuits. As I mentioned earlier, total monetary damage is capped at $30,000. It is a voluntary proceeding, meaning that parties can opt out. And finally, it safeguards against abusive practices. Next slide, please. Before I conclude my presentation, I'd like to address a few copyright myths. Myth number one: you must register your work to own the copyright in it. As I discussed earlier, this is not the case. Neither copyright protection nor copyright ownership depend on registration. Copyright protection is secured automatically when a work is created and fixed in a copy or recorded for the first time. And although registration is not required for copyright protection, it has certain benefits that I described earlier. Myth number two: you must put a copyright notice on your work to protect it. As I mentioned before, this myth was once the law in the United States. A work published without a copyright notice could lose US copyright protection permanently. The notice requirement, however, was abolished when the United States joined the Berne Convention on March 1st, 1989. So the copyright notice is no longer required and does not affect copyright protection, but it still serves a number of useful purposes that I discussed earlier. Myth number 3. If it's on the internet, it's in the public domain and free to use. This is another common myth. Copyright law applies equally to the internet. So if copyright protected material has been shared or displayed on the internet, it is subject to the same rules against infringement as material distributed in the offline world. It also does not mean such a material is automatically in the public domain and is free for taking. A work of authorship falls into the public domain only when it is no longer under copyright protection or if it failed to meet the requirements for copyright protection in the first place. Once in the public domain, works may be used freely without the permission of the former copyright owner. In addition, certain works are automatically in the public domain because they constitute an unprotectable subject matter, as I discussed earlier, like individual words, short phrases, or works created by the US government. If you wish to use copyright protected material you find on the internet, the safest course of action is to get permission from the copyright holder or consult an attorney with experience in copyright law, or both. A possible alternative is to use material published on the internet under a Creative Commons or similar license that allows use without further permission under specified conditions, such as providing attribution and using the material for a non-commercial purpose only. Myth number 4, copyright protects hard work. Sometimes referred to as the sweat of the brow doctrine, it mistakenly asserted that copyright rewards the work that goes into researching and compiling facts. This principle, however, was rejected by US Supreme Court in FICE Publications case in 1991. In that case, the court held that it is originality, not effort, that is the basis for copyright protection. But the good news is that copyright may still protect original selection or arrangement of the material or any other original elements the author added to the project as a compilation. Next slide, please. Myth number 5. If I hire a freelancer to create a work, it's a work made for hire and I will own the copyright. If a freelancer, being an independent contractor, creates the work for you, it will not be considered a work made for hire even if you pay for it, unless 3 things happen. Let's review the work made for hire doctrine that I've discussed earlier. The work must be specially ordered or commissioned. It must be ordered or commissioned for use in one of 9 categories listed in the Copyright Act, and both you and the freelancer expressly agree in writing that the work will be considered a work made for hire. All 3 conditions must be met. So if you sign a contract specifying that the work is specially ordered and is to be considered a work made for hire, but it does not fall into any of the 9 categories, it will not be deemed a work for hire. Myth number 6, I can use up to 10% of a copyrighted work without permission because that would be a fair use. While it is permissible to use limited portions of work for purposes such as commentary, criticism, news reporting, and scholarly reports, there are no legal rules permitting the use of a specific number of words, a certain number of musical notes, or percentage of work. While it may seem intuitive that you should be allowed to use just a small portion of a work, the third factor, amount and substantiality, is qualitative as well as quantitative. If the portion you take is especially important, goes to the gist of the work, the taking could be an infringement, even though the amount seems small. As I noted earlier, whether a particular use qualifies as fair use depends on the specific circumstances of a case, weighing all the 4 fair use factors. Myth number 7. I may use protected material without permission if I use it strictly for educational purposes and give the author credit. There is no blanket exceptions for all educational use. The general rule is that only the copyright owner may copy, distribute, perform, publicly display their copyrighted material or make derivative copies, derivative works. Everyone else must get permission, including educators. However, there are some limited exceptions for educational purposes. For example, performance or display of a work by instructors or students in the course of face-to-face teaching activities of a nonprofit educational institution in a classroom or similar place devoted to instruction. In addition, in some instances of educational purposes may qualify as fair use, but the purpose of use is only one factor in the four-factor fair use analysis. Courts have found no fair use even where use was for educational purposes. Finally, despite a widespread but mistaken belief, giving credit or attribution without having permission to use the work does not absolve from liability for unauthorized use of the copyrighted material. And finally, myth number 8. If the copyright holder did not register their copyright, I cannot be sued. While registration is a prerequisite for filing a copyright infringement suit, it may be made at any time within the term of the copyright. So if the registration is made within 3 months of the first publication, it will provide certain additional benefits, such as statutory damages and attorney's fees, as I mentioned before. But the fact that the copyright owner has not yet registered his or her copyright will not prevent from filing a suit against the copyright infringer. Next slide, please. This slide shows some additional helpful resources for more information about U.S. Copyright Office registration practices, copyright basics, and fair use. This concludes my presentation. Thank you for your attention. I hope you found this interesting and informative. And I think now we'll take questions. Right, Amanda?
Yes, that's correct. Yep, we have a few questions here. Let's see here. Someone's asking about the author. So if I understand correctly, the author J.K. Rowling is protected overseas. I think this is on international.
Mm-hmm. So under the national treatment, yes, but also the books of Harry Potter, they have been translated, and there were also adaptations, like the screen, all the movies. So they are protected to the same extent that the US works are protected.
Great, thanks. I have a couple questions in case anybody else asks this. I'm going to answer this now. Will the recording be available after this? Yes, we're going to send out the slides and the recording to everybody after this. So stay tuned for that, everybody. Do I need a lawyer to file copyright registration, or would you recommend I do this on my own? Is there a streamlined process for self-filers?
So it would depend on the case. So if it's a straightforward case where you created a work without using any pre-existing material, let's say you made a photograph of a landscape, using your camera, setting everything up, and it was solely your work, then it would be a straightforward case, and generally no copyright lawyer would be required. You just go online, create an account with their filing system, submit all the information, and pay the fee, either attach a digital copy of your work, or if you want, you can also deposit the original, then you would need to mail it. And the copyright specialist will review the application, and if everything is good, then the registration certificate will follow. So for cases that are straight like this, there is no need for copyright attorney to be involved. However, for more complicated situations involving, let's say, movies or books that they have illustrations and cover art design, and maybe a few co-authors. In that case, if you're not familiar with the copyright law and cannot fully figure out what kind of pre-existing material you should claim, so there might be instances where it would be good idea to consult or engage an attorney. But as a general matter, copyright registration is not as complex as patents and trademark registration. So a lot of authors, a lot of small businesses and entrepreneurs just file by themselves. So there is a streamlined process for self-filers, and I believe that U.S. Copyright Office, they have some educational videos or like some educational instructional materials that are helpful, that guide you through. So I hope this answers your question. Thank you for your question, by the way.
Thanks. Can you will your copyright to someone?
Yes, you can. So copyrights are transferable, and they can be transferred by you to explicitly through non-exclusive writing license or exclusive license. And also it's an actual intellectual property right, an asset, and it can be subject to wills and trusts.
Great, thanks. What if I have more questions? This sounds very difficult and I need clarity on some topics.
Yeah, you can send them through Amanda, and I'll try to respond to them.
Yeah, and we also have this, you know, I'll put back this other slide here, and we'll be sending these slides out with the links, so you'll be able to look at some more resources here.
I agree. It's a lot of material, and I try to squeeze it in, and you know, to be concise, and also to give examples so it would be more relatable. But it's a very complicated area of law, and that's why I also included this information, the resources that you can refer to if you have any further questions. But if it's something specific that you cannot find there, reach out to Amanda, and she'll reach out to me, and we'll try to get the responses that you need.
Thanks. Are images from social media copyright free?
Not as a general matter. Anything that has been, it will depend. As lawyers say, right? It depends. It depends when it was created, whether it was created by U.S. government or whether it was created by someone who died and 70 years passed. So probably the rule of thumb would be if you see something on social media or any other places on the internet, probably the safest way of thinking would be it's probably copyrightable material. And then if you need to use it for any purposes, then you would need to make that decision, you know, can it be fair use, right? Like go through those 4 factors just to do the preliminary determination. And usually a lot of digital photographs online, they have embedded information about the author, the photographer, when it was created. So that also can be helpful for you to identify, you know, whether it's protected, because if it was created in 2021, you know, the chances are it is protectable. But if it was created like in 18th century, it is like less likely that it's still protected. And also, you know, again, depending on the purposes of your use, you may try to find information about the photographer, how to license it on photo banks. You can run the Google image search, and it will help you, you know, to find where that image appears online, and track the photographer and see, you know, if it's Creative Commons, or if sometimes some photographers allow use of their photographs in low resolution if it's for nonprofit educational purposes and attribution is added. But if there is no Creative Commons license like that, then probably you would need to find a way to pay a license fee. For photographs, license fees can be on a large scale of money. So, but this concise response, if it's something on social media, it's probably a copyrightable subject matter.
Great, thank you. There's a couple of kind of similar questions here. I'm going to kind of put it together to help clarify public information versus copyright information. How does one tell the difference between public information and copyright in writing historical fiction? For example, is the height of the Washington Monument considered public information?
I don't know where we do have a definition of what constitutes public information. Thank you. I'm sorry. Thank you for the question. It's a good question, and it probably involves some other areas of law where the public information is defined. But in terms of the copyright, if it's a fact, right, the height of the Washington Memorial, it's not protectable subject matter. However, if, let's say, someone writes a small article describing the history of creation of the Washington Memorial and uses some, not just facts, but also add some creative expression, some metaphors or anecdotal evidence, or something that is not just mere facts, then as a whole, that article will be protectable. What's copyright is interesting is because, like, for fictional works and factual works, both of the works will be most likely protected by copyright, but the fictional works will have a stronger copyright protection because they would involve more copyrightable elements that use imagination, characters, and phrases. And factual works will have what we call thin copyright protection, which means that only the specific phrasing, like, or the totality together, the entire work will be protected by the factual. So let's say if you want to use that article to refer to the facts of that article, then you can do so. And that also is covered by fair use if you are using it for news reporting, criticism, or commentary. I hope this answers your question. If not, please follow up.
Thank you. Oops, I lost my slideshow. Well, if I reference a famous phrase from a copyrighted work and give the author credit, is that okay?
It will depend on the specific circumstances, how creative that phrase is, and what kind of work it is, and how you use it. So giving a credit is just generally good practice, but as I mentioned before, it does not absolve of copyright liability. How you would use it, that famous phrase, it would also depends. Like, if it's just a side of, let's say, even like, if it's aside from a book and you are using it in your book to relay some message, let's say you have a book and one of the book characters says to another book character, oh, I recently read this interesting poem, and then cites one verse of that poem. It might be okay, but I will be on the safe side here and wouldn't say affirmatively every time it would be okay. It will just depend the context of use, how you use it, where you use it, and how recognizable that phrase would be, because there's a lot of like different litigations going on, and including like the use of the name of the song or some phrases or quotes from books or movies. And it's never a straightforward answer. As much as I would love to give you, yes or no response, unfortunately, I can't. So it will depend on the specific use.
Great, thanks. I'm creating educational materials and use an excerpt from a published author. Do I need to get their permission, or is it okay to just credit them and their work?
So if it's an excerpt for, and you're making some, scholars, like if it's a research paper, if it's some commentary, just an excerpt or rephrasing would be, it should be fine. I mean, for the most part. So unless if it's not just, one or two sentences, but it's more like a paragraph or pages of using someone else's work verbatim, right? Like we're not talking about situation where you are writing, I don't know, an analytical paper or a book for instructional material and you paraphrasing. You need to credit because it's just the rules of plagiarism, which are not part of the copyright law. But when we're talking about verbatim copying, right, like when you're using quoting exact words of that published author, again, it will depend on how much you cite. And, so if you cite not much, it favors fair use. If you are doing this for educational materials, for nonprofit education, non-commercial purposes, it would likely favor fair use. So I think that's it. That's all I can say.
Thanks. How about kind of in a similar question, in a historical fiction book, should you acknowledge your historical sources? And how would you do that?
Could you say again?
Yeah, in a historical fiction book, should you acknowledge your historical sources?
Yes, but it really does not have much to do with the copyright. I mean, there is such a concept that I have not discussed that's called moral rights, and they include attribution. So just a general practice, if you use someone else's work, it's a good idea to, acknowledge and attribute the sources you used. In terms of, whether it's how you, I think it's just you list in the, you use footnotes, and then in the end, you can add a list of resources used. Think of maybe like any books, that historical books, right? Like when you open the, in the end of the book, there is the list of resources. And when you read the book, and if they cite verbatim or making some point from previous books, then it has footnotes. So I think that's how you do it. That would be best to do it. Yeah.
Great. Well, we are at 1 o'clock, so I think that's our time for today. But thank you, everybody, so much for your questions. Thank you, Marina, for the awesome presentation. I just want to let everybody know again, you'll all receive an email with a link to the recording and evaluation and to the slides. If you would like to sign up for upcoming webinars or access recorded past webinars, please visit virginiasbdc.org/training. All of our resources here at the SBDC are designed to be used in collaboration with your local SBDC advisors, and you can sign up for free and confidential session by emailing help@virginiasbdc.org or via our website. So thank you all so much for attending, and we hope to see you in our next session.
Thank you, everyone. Thank you for your questions. Have a good day. Bye.